Start करू Chetan sir?
Yes, sir. Yes, sir.
Okay, good afternoon to one and all. Myself, Dr. Dattatreya Kalbande, IQC coordinator and librarian of J. Vatumal Sadhubela Girls College, Ulhasnagar, Maharashtra, India. I welcome to all of you in today's webinar entitled Intellectual Property Rights, Patent Preparation and Prosecution. Today with us have as a keynote speaker Dr. Nagare Kantilal. Also today's esteemed speaker Ms. Pooja Menon, our principal Dr. Vasant Mali, and my gurus Dr. Anil Chikate, Daya Dalvi Madam, Dr. Kulkarni sir, my beloved friend Chetan Taksale, and all esteemed participants from the all over world join with us. Uh, Before starting, I would like to say that for this webinar, we received overwhelming response. More than 1,700 participants registered from the all over world, and 32 participants from the out of country, including Philippines, Indonesia, Pakistan, Iraq, Ethiopia, South Korea, Sri Lanka, UAE, and Yemen. Also from the India, almost all states representative registered, and another beauty is that the participants from the principal group, from the scientists, from the professors, from the librarians to attendant, from the school teachers, students, PhD scholars, and agriculture scientists. All of you know that this webinar arranged on the occasion of Dr. S. R. Ranganathan.
Yes, sir.
Anniversary. So in the beginning, I would like to say about Dr. S. R. Ranganathan in very short, because lot of the peoples are from the out of library and information science, and they don't know about the means not familiar with about the Dr. S. R. Ranganath. Padmasri Sriyali Lamamitra Ranganathan, who is the doyen of library movement in India and popularly known as the father of Indian library science for this immense unparalleled contribution to the field. Library professionals celebrate Dr. S. R. Ranganathan's birth anniversary on any of the day falling between the 9th to 12th August every year to commemorate and remember his contribution to the librarianship. Also on the 12th August all over India, we celebrate as a National Librarians Day. Dr. S. R. Ranganathan started his working from the Madras University as a librarian. Afterwards, he associated with the various universities and institutions all over the India as well as the abroad. Even he was the associated with Pune University, even Mumbai University also. He was a prolific writer with over 1,200 research papers, 53 books, and was editor for 5 periodical publications in his lifetime. One of the most notable contributions to the field is that 5 laws of the library science, and he is proposed in the 1931. First law is that books are for use. Every reader his her book. Every book its reader. Save the time of the reader, and the library is a growing organism. Keeping in view of various wonderful contribution, the Indian government bestowed to him the honorific title, that is the Rao Sahib, in 1935. He was also awarded Padma Shri in 1957 for his invaluable contribution to the library science. Government of India recognized him as a national research professor in library science in 1965, where there were only 4 other professors in India during that time. So this is an very great honor to library and information science professionals. Also, he is known as the father of Indian library science for his immense unparalleled contribution to the library and information science field. And on his birth anniversary, on the behalf of all of you, I pay homage to Dr. S. R. Ranganathan, a great seer, on his 120th birth anniversary, remembering his contribution to the towards the field of library and information science. Now, may I call to our principal, Dr. Vasant Mali, for introductory speech. Over to you, Mali sir.
Hello, I am audible.
Yes, sir.
Thank you, Dr. Dattatreya Kalbande. Good afternoon to all. It's my great pleasure. I warm welcome to today's resource person of this webinar, my friends Dr. Kantilal Nangre, Department of Zoology, Birla College, Kalyan, and Miss Dr. Pooja Menon, COO, Mycrave, Vadodara, Gujarat. Dr. Dattatreya Kalbande, Organizing Secretary, today's webinar, Mrs. Nitu Purusani, Head of Department of Commerce, my teaching staff, dignitaries, principals, faculties, and participants from India and abroad, UK, Iran, Philippines, America, Nepal, Bangladesh, South Africa, etc. I am happy to sharing my view uh, in in front of you. Internal Quality Assurance Cells and Department of Library Science at Department of Library, J. Vattumal Sadhubela Girls College, Ulhasnagar, organized a national level online webinar on intellectual property right, patent preparation and prosecution on occasion of birth anniversary of father of Indian Library Science, Dr. S.R. Ranganathans. First, I congratulate to my colleague and very active and energetic person, Dr. Dattatreya Kalbande, successfully organized national webinar within a very short period. For this seminar, registered 1,700 participants from India and abroad. J. Vattumal Sadhubela Girls College started its POS journey with blessing of Acharya Swami Ganesh Dasji Maharaj, the founder of Sadhubela Education Society. He believes that the need of the time is to nourish the student for all-round personality development much beyond academic excellence. The weaker female section has been neglected by Indian society since centuries. The kind heart of Swami Ganesh Dasji Maharaj inspired him to start the educational institute exclusively for girls on a piece of land measuring 2 acres in congested city of Ulhasnagar. This college made a humble beginning its academic year 1994 with only 38 students, a single department of commerce. It is only girls college in the Mumbai central suburban area which include Thane, Kallas, Ulhasnagar and Ambernath. Our college staff is very efficient and active. From from March, college staff had reached in all issues related to learners, academicians, scholars by conducting various online sessions such as MCQ test, FDP, research stress management, fitness program, and now finally it's time intellectual property right. On 23rd March, arranged MCQ online test about COVID-19 awareness program. For that test, 2,850 participants were responded. On 27th April, successfully organized a national level webinar on intellectual property right in India. For this webinar, above 500 participants were responded. On 12th May, SNDT Women's University, Mumbai, successfully organized a 7 days international faculty development program from 12th May to 18th May in collaboration with our college. For this international faculty development program, 2,750 participants registered from 11 countries and above 6,000 participants was watching on YouTube for 7 days international faculty development program. All session resource persons were invited from abroad, Australia, America, Switzerland, Netherlands, and Bangladesh. On 16th May, college organized a webinar for college students on stress management. On 21st May 2020, successfully organized a national level webinar on research methodology. 2,300 participants were registered and above 1,500 participants joined through YouTube and Zoom. On 3rd and 4th June, organized a 2 days national level webinar on investing in these challenges, times, and Indian economy row head in collaboration with Bombay Stock Exchange Brokers Forum, Mumbai. I am very much thankful to our management Mr. Uttam Singh Pawar, ex-member of Parliament and Chairman of Sadhuvela Education Society. Mr. Nitin Sri Krishna Bagwe, Secretary Sadhuvela Education Society, for given permission to organize online national level webinar on intellectual property right. I am thankful to today's resource person, Dr. Kantilal Nangre, Mrs. Pooja Menon, and Softtech Solution and Services Pune for uh, provide the technical supports, and all participants for your participation and valuable supporters for online today's national level webinar. I assure to all participants, this webinar is very useful. This webinar is very useful. This webinar is very useful for all. I sincerely hope you will enjoy today's online national level webinar, intellectual property right, patent preparation and prosecutions. Thank you. Stay at home safely. Thank you, sir.
Thank you very much, sir, for detailed introduction of our college as well as events organized in this pandemic situation. Really, all these work are only because of you, or on the basis of your inspiration, encouragement, and the motivation. So, thank you very much, sir, for your kind words and appreciation. Now,
Welcome, sir. Welcome.
thank you. For today's webinar, with us have Dr. Kantilal Nagre, Assistant Professor, BK Birla College, Autonomous Kalyan, as a keynote speaker. Sir has more than 15 years experience in the field of research as well as the teaching. On his credit have 4 books, and out of them 1 to 2 books are accepted by the University of Mumbai for the syllabus. And several papers he is published in the UGC listed journals as well as international journals. Apart from this, the notable research is that sir you have 5 patents on his credit, and 1 patent is in process, and then that patent he will be give to the ICMR free of cost. And for this contribution, sir, very big congratulations to you and clap for this wonderful research. Apart from this, sir, he have very good mastery in the NCC. He attended various training programs and got the lieutenant degree under the NCC. So socially touch personality with us here. Also, he have very good knowledge of spiritual good knowledge. With us have I can say the versatile personality, that is the Dr. Nagre sir. So I request to you, Dr. Nagre sir, please give your keynote speech. Over to you, Dr. Kantilal Nagre.
Thank you, sir. Thank you, Kabande, sir. Thanks for the nice introduction. Yeah, I'm waiting for my new patent to get published, which is related with the breast cancer. And I have already 5 patents, and I'm working on another 3 patents related with the staining techniques. Basically, I'm endocrinologist, the branch of zoology.
Yes, sir.
Principal Vasant Mali, sir. Namaskar.
Namaste, sir. Namaste. Namaste.
Thanks for giving me this
Good
opportunity.
afternoon.
Good afternoon. Really.
Welcome, sir. Welcome.
Suresh, sir.
Welcome.
Good. Thank you, sir. Rinke, sir. Thank you. Kindly permit me to start with the my presentation with
Yes,
with due regards to Padma Shri S.R. Ranganathan, sir, on behalf of which we are going to conduct the webinar.
Yes, sir. You can.
Yes, sir. Thank you, sir. Sir, it is National Webinar on Intellectual Property Rights and Patent Preparation. In this, I am going to cover that what teacher or what the teaching line faculty has to perform, or how the teachers will have more patents, how the researchers, the new PhD students should look after towards the patenting side. I heard that there are 117 participants from all over the India and foreign participants. It's a humble request. If you have any queries, please write on the box so that at the end of the session we can answer for that. स्क्रॉल होते दूसरी So why we need the patent? Need of the patent in current scenario. Sir, we see that there are lot many researchers, lot many students that are doing research, but the link between the researchers with the company has been de-linked. We have to link our research. Unless and until we link our research with industry or companies, our research will not be valued for the society. Application of the current research in doctoral degrees are there, but if you are PhD with patent, immediately the credit will increase. Our Modi sir, the Prime Minister, has given us the Nara of Make in India or Swarnim Bharat. Everything should be prepared in India so that the revenue generated will be more. And patent, of course, will help us for the Make in India movement. Nowadays, after PhD student asks their guide, sir, what should I do now? I am PhD. Give me a job of CHB or lecturership or something like that. But entrepreneurship is a good option for that, because the small scale industry, SSI, if you have a patent, the permission to start with small scale industries, and then loans, getting loan will be easy. And with you also start the industry, and with you are liable to give job for more jobless entrepreneurs, interested people. So this is good opportunity which gives you personal recognition. The moment you say, I have published so many papers, I have published this, and I attended this conference, nothing to give. When you say I have a patent of this, immediately the society will look at you with a different scenario. Then one small option, the API, for which the teaching faculty, teaching fraternity, they keep on struggling. Mostly my talk will be helpful for research organization, researchers, or PhD student who are doing PhD. Try to correlate your research with patent. It's very simple definition given. Patent is a legal document that is granted to an inventor by the patent office, Controller General of the Patent and Design and Trademark. Convenient application for the patent made by the virtue of section number 135 of the Patent Act. Patent will be granted only if it will satisfy the conditions of the patentability, and here the problem lies. I met with many PhD guides. I met with many research scholars. They have the research, they know the concept, they know what is patent, but they are lagging with patentability. That is, your research, how will going to convert into patent? That is known as patentability. And today in India, the problem is the patentability. Here the conceptual, the problem is with us. The researchers and the students are lagging behind with the patentability. Why to go for patents? Why to go for patents? Sir, when I was MSc and when I did MSc in 90s, there was respect for the teacher who are with MSc. Then after 2000, there was respect for the PhDs. And today, nowadays, they stop their education till PhD. And they will ask you in future that all are PhD, how many patents you have? India is moving towards patent. It is a call of the time. It is Samay ki Pukar. See, we got lot much scope about patentability in India. China last year posted around 15 to 16 lakhs of the patent. USA has 5.7 to 6 lakhs of the patent last year. Japan got 3.2 to 3.5 lakhs of the patent last year. But what is condition of the India? India, around 48,000 patents were applied and only 4,600 were granted in the last year. We have 4,600 patents granted last year, but we have submitted around 23,000 of PhD thesis. And out of this 23,000 PhD thesis, 9,000 were from science. And I know if the patentability is the potential, if they know about the patentability, what I speak about previous slide, if they are having knowledge of patentability, out of 8,000 patents which they have submitted already, 8,000 PhD thesis which are submitted already, we would have got at least 15 to 20,000 patents. And that is why the India is lagging behind. There is a good scope. There is a large scope in India for the patent. Patent should have novelty, something new. Patent doesn't need a big laboratory, a big prayogshala. Patent need just thinking process, new novelty. Patent should have non-obviousness. If the patent have industrial application, it is accepted and it will lead you for the entrepreneurship. In-depth practical approach is most needed for any of the patent. This ability should be there in individual. This ability should be in the individual. Novelty or turning your patent to the novelty is the job of a legal advisor. The patent officers and patent legal advisor, they very well help you to have converting your PhD or your research in the novelty as well as non-obviousness. They are expert in that. Patent is needed. It will increase the public image of the department as well as for the institution. See, you keep on applying for different grades, and your college is kept visited by many experts. The moment they come to the department introduction, when you say, wow, there's many patents in the department, immediately the acceptance signals are given. Improvement of the quality of the research in the department, this is a great achievement. The moment you see, the moment the student get a patent, any student, undergraduate, postgraduate, or a PhD research scholar student, he get a patent, how happy he is, and the way he will handle his sibling, my God, you cannot explain in the world. I know my undergraduate student, I know my PG student, they have patent and how efficiently they are working in my department. It increases opportunity for the research funding also. This is nowadays there is a problem that the fund, and when you have your work related with the patent, the funding is made easy. Sustainable high scholarship level is also another opportunity. Patent benefit: student, research scholars, and guide and mentor success and satisfaction. Sir, you cannot just word dissatisfaction in the world. National and international recognition. In old days, they were saying that. In old days, they were saying that if you want to have a patent, you should have a big laboratory. Your laboratory should be internationally recognized. You should have this instrument and that instrument. It is no. It is not that thing. See, in my new patent, I'm working on histopathology, and for histopathology, what you need is only wax and alcohol in the laboratory with one beaker. And there is a wax and there is alcohol ample in every department. And I'm working on 3 new patents on that. So very easy. Not like your library should be very big, but once you get the recognition, I mean, for the patent, your lab will be recognized for many national and international laboratories. Startup recognition of a small scale unit in the Maharashtra earlier, which was not there. Now the small scale industry. There is one clause in patent they have added from few years back, that if you have a tie with any of the small scale industry, and if you have patent to start after the patenting, if you want to start with collaborate with that small scale industry, the government of India grant you patent within 3 months to 1 year, maximum 1 year timing. Our expert, Priya Madam, will go into give emphasis on that. Royalty income is one of the good income. See, teachers, they work, they get a salary, but with the with the patentability, they can start with another source of income as a patent guide or a patent agent also. Industrial avenues are there, industrial consultancies, you can start very well. Even I am also doing industrial consultancy. Of course, I am doing industrial consultancy free of charge to the newcomers. I am not charging with them. Until today, in last 2 years, I have consulted around 13 industries and 2 more industries are in touch with me. A special consideration for career advancement scheme, annual performance index, PABS, PG or PhD guide, etc. I know some of the students in Bombay University, they have submitted the thesis with thesis for PhD Viva, and then their experts, the one who came for the Viva, immediately told them that, see, you have done the research and you already published the patent on that. So this is having published patent with your research is one of the confirmatory test. Some formalities are remaining, and then the degree was given easily. Special consideration for institution in AICTE ranking, NAAC rank accreditation, NIF accreditation. I know myself also, in my college also, or everywhere. The moment you approach to the management, the moment you approach to the principal or director, or the moment you approach to the industry that I am a scientist with the patent, I am guide with the patent, I am man with the patent, the way they accept you, the way they take your guidance, the special consideration they give is one of the good factor. Fastest processing of entrepreneur application is good thing with Maharashtra Pollution Control Board as well as National Biodiversity Board, and there are many such government bodies. When they apply with the patent, they uh, process their application very fast because scientific concept is more clear with that. Teachers and researchers can go for, I know out of 1700, Mali sir and Albandi sir, with due respect, told me that most of us are teachers, most of the participants are teachers. So I added this one special slide for the teacher. Teacher can go for, very well go for utility patent, new or improvement product. What is utility patent? How to form the utility patent? We'll go into discuss in coming slides. Design patent is one of the good opportunity for the computer patent or technical computer teachers or technical teachers from all the engineering faculty. You can very well design the patent, and you can there is no challenge for design patent. Once your design is accepted, the government grant you patent very well. And you know, most of the patent granted last year, those patent granted last year, most of them are from design patent only. Number of patents in the single production, commercially available daily utility goods, that is toothbrush design. We're going to talk in detail about this single product designing. Pooja madam have some example about the single product designing patent. She will be emphasizing more points on that is already discussed with us. Yeah, this is one slide I would like to highlight. Teachers and researchers should not go for teachers and researcher. Please mind well, teachers and researchers should not go for improvement of the existing patent. Normally, it is seen that most of the teachers, they take guidance, and then they take the guidance and they said, okay, we are working on this line, so let me start work on the same line, and then they copy the thing, and when they copy the thing, they very well get trapped with the first or second examination report during the legal defense. They are in trouble. So teachers, if they are doing improvement in the existing patent, please take the advice of the owner of the patent, and then legal advisor, and then the patent officer, and then only draft it. Otherwise, you will be in great trouble, because by the time you publish the patent, it is after 18 months, and after 18 months, when you face for the examination, first examination or second examination report, you are already wasted 2 years or more than 2.5 years, and then you are in trouble. You have to give back the patent, and then your PhD student will be in trouble. You will be wasting his 2 important years. So you can go for improvement of the existing patent, but just think and then only do. Researcher can go for priority patent filing. This is a good thing which Government of India has given us the opportunity. priority patent filing. You know, priority patent, you can file the patent priority only title. You can file the patent priority only title and some ideas, and then the timing available with you is at least 4 years. So within 4 years you can make a priority patent into confirmed patent. So good timing is there. And economical also, they charge only 4,000 rupees once at one time. So within 4,000 rupees you can block your idea and you can confirm the patent. There is one clause: if you doesn't successful in getting the patent, you can cancel, take back the application, and then nothing goes wrong with your career also. Invention of invention which are not patentable. This thing they keep on asking that which things we should not patent. See, atomic energy related invention with atomic energy, invention which causes serious project visitors to human, animal, or plant life, discovery of living or non-living occurrence in the nature. You cannot patent is already so-called Nisarg Bhagwan or God nature has already created them. You cannot patent them. A presentation of the information you cannot patent because it is a physical information of one thing. Agriculture or horticulture, a traditional method. Not only agriculture and horticulture, but in nothing traditional you can patent. Nothing traditional. It is usual practice going on, including traditional medicine. You cannot patent. Only computer programming you cannot patent, but programming with hardware based on that particular is patentable. With the advice of the legal advisor. I'm always using the term legal advisor. The reason behind that, we become graduate, we become postgraduate, but we study very less in the legal aspects. We don't know how to formulate it, that particular legal concept, and only legal advisor. Legal advisors are like us only. They are postgraduate, graduate in our subject, but extra they are LLB or LLM, and they know the typical legal drafting which we lag behind, and they help us to and their legal drafting help us for facing of the examination report and back answering of the defending of the patent with various aspects. So please be in touch with the legal advisor or patent agent. Persons entitled to apply for the patent: person or a team claiming to be true as a first inventor. Anyone who is a citizen of India whose claims as a true or first inventor can apply for the patent. There is no basic qualification for the patent. There is no basic qualification for the patent. There is a basic qualification for patent advisor. There is basic qualification for patent legal advisor, patent agent. But anyone Indian citizen who is first inventor can go for the patent. The laboratory recognized for the research, you should attach with some of the laboratory which is recognized for the research, which will be helping you for further defense also. Form of the application: every application shall be for one invention only. This is needed. If you have in single application, if you include 2 patents, and if one of them get rejected, both the patents will be rejected. So please take care. Don't save the money in application. Application charges are very less. For the student, it is only 2,000, or for private patent it is only 4,000. So pay a less amount, but in one application apply only one patent. Filling the date should be there, because this date is important. The moment the date you file the patent, from that particular date in the future you are getting the patent. The patent is awarded always backdated, so your date should be there with complete specification. Application stating about invention, claims, and methodology should be clearly mentioned, because once methodology is mentioned, you cannot change it. Once inventions are mentioned, what type of invention you are going to do, what claims you are going to opt, that should be made clear, because hereafter you cannot add more claims. You can reduce the claims, but you cannot add more claims. The government of India has given us facility that you can have 10 claims in free of cost in one patent. Information undertaking foreign application: please take legal advice. India got treaty with 180 countries. And laws of every country are different. A single application one single application. You can have with foreign collaboration a single patent with India. You can go for many of the like foreign countries patenting. Go for that, but please take the legal advice. Provisional and complete specification that the legal advisor will tell you. Persons, company, department who are involved, what will be their role, what is their participation. Please be specific for that. Concept of specification. Yeah, this is important. Contents of specification. You are claiming something. You are claiming something, but that claiming should be supported. Like someone working on a testicular slide. In the test there are sperms, and sperms are stained with methylene blue. So that particular photograph should be there. How the methylene blue is prepared, that particular content should be there. That is your methodology and all that supportive documents you should attach with the patent application. It is only one time chance you are getting. Thereafter you cannot alter it, because if you alter it, your patent will be new patent. Obligation and examination of the application. No application for the patent is examined unless the applicant make the request for prescribed manner of the examination. These two first lines are important. When they apply for the first time, they don't know that we have to fill another application for the examination purpose. Unless and until you fill the application, new application, and give the patent board for the publication, patent board doesn't go for the publication examination. You have to fill the application. Otherwise, what happens? After 18 months, when you publish it, after 18 months, till the gap of 18 months, if it doesn't fill the application for examination, your patent get automatically non-granted. It get rejected. It will get rejected. I studied the figure. Last year, 45,000 patents were applied, and only 4,500 to 5,000 patents were granted. You know the condition. Around 16,000 patents are rejected because they have not applied for examination. They don't know it, and then they got rejected. If not the application, after that, after time of the publication over, consider that withdrawal is application automatically happen. Consideration of report of examiner by the controller given the opportunity of the hearing. As you apply for the examination, the controller, they see your examination report and then they give you opportunity of hearing also. They call you for conference call, they call you for Zoom meeting, they call for mail, and they ask a question, and then you have to clarify their doubts, because they are doing examination. Either they even I saw the controllers, they performing the practical themselves and checking it. Power of controller to refuse or suggestion of the required amendment if satisfied with the application. Yeah, I know patent agent controllers, they give suggestion also. Ma'am, sir, please instead of this term, write like this. It will be helpful for you to get the patent more successful. They are helpful, but these all things happen unless and until you fill the examination form. Power of controller in case of anticipation or acceptance, very helpful, such as wait till the NB approval. I know biologists, they apply for the patent and then they need the approval of NB, National Biological Authority, SBA, State Biological Authority. Unless and until you get the NBA, National Biological Authority, your patent cannot be granted. And if the if you applied for the examination, in examination the NBA report is there. But if your NBA report is not there, the controller stops your patent till the NBA approval comes. They don't withdraw your patent. They are very helpful. They don't withdraw your patent. That is what the examination forms help you. Power of controller in case of potential breaking the terms of law. See, some of the terminologies which are claims, if the controller, if they fail, they reject the patent and they tell you, they guide you by deleting them, apply another patent. This is what the legal background. This only legal person, legal people, they look after this. Opportunities proceeding to grant of the patent. Patent has been published but has not been granted. The opposition can be raised. Opposition, see, once you publish the patent, it is online for 18 months. Until 18 months, it is visible to all like so-called scientists. And any published patent which is not granted, you can raise the opposition. Any claims of the complete specification has been published before the priority date of the claiming. I told you previously that your date should be important. If your publication date should be, your application date is important. If you applied on that particular day on which the claim is not published by anyone, the opposition can be suppressed here. A claim in any claim is publicly known. Traditional medicine order cannot be accepted. Right of co-owner of the patent. There is no concept like co-owner. They're all patent owner are equal. Reference the section number 51, Patent Act 1970. All are entitled to have equal in undivided share in the patent. When you publish the paper, the first author is important. The last author is important. In between are of little bit low grade. But it is not the case with the patent. All, though your name is on the first position, though your name is on the 10th position, you all are with the equal rights. Patent of addition. Application made for patent in response of any improvement or in modification of the invention described, disclosed in the complete specification filed therefore. When an invention begin an improvement or in or modification of the another invention is a subject of independent patent. See, they do research. Their research theme is same. Today they got invented this, and tomorrow they will have invention another thing. The third day they have invention of another thing. But in this invention, there is slight improvement. Never mind. Please go for that. Please go for that. Because you can have additional patent, and these additional patents are always new patent. I have a fan with 3 blades. Tomorrow I invented fan with 4 blades. It is a new patent. The day after tomorrow, I invented a fan with 5 blades. It is a new patent. I am working on the blades of the fan, but my patents are increasing because the purpose is different. The outcome is different. A patent of additional shall not be granted before the grant of the patent for that particular for the main invention. This is the legal statement, and that legal will look and modify it accordingly. This is important for the additional patent. Restoration of the lapsed patent. Sometimes patent get lapsed. See, 16 months you have not filled the examination forms, and then the online, if you check it, it is mentioned that your patent is lapsed. Okay, no problem. The government of India has made a clause that section 4 of the subsection 4 of the 142 says that if your patents are lapsed within the 18 months from the date on which the patent is seized, the same patent can be rejuvenated. The benefit is that you are rejuvenating it from the backdated event, that is 3 years back. The date will be given to you by the patent office. Surrender and revocation of the patent. At any time, you can surrender your patent. Why? Invention listed or claims listed are honored in the complete specification of another granted patents. There are many reasons. The legal advice, the patent controller, the patent examiner, they tell you that please surrender your patent and revocation it. Go for revocation of the it. You can reapply for the patent, which will help you to save your time. Sometimes your claims get matched. Sometimes your claims get clash. You don't know that someone in the Germany, someone in the Assam, Nagaland, Manipur has already been claimed with the same patent, and then you apply for that and your patent get rejected. But surrendering to your patent will stop your patent in getting rejected. You can resubmit it by deleting those patents. That is what the benefit you are getting after surrendering and revocation of the patenting. Registration of the patent after publication, examination report, completion of the legal and scientific proof get automatically registered and granted. It gets granted with the backdated. With the backdated, that is the date on which you have applied for. Okay, let's start with a new beginning. We're going to start the patent. Okay, thank you, sir.
Please, sir, please close your slide sharing. Thank you very much, Dr. Nagre, for your valuable thoughts on the patents. Particularly, I know most of the participants from the science field and from the information technology, even you have to clearly mention that there is a no qualification for the registration or for the getting the patent. So that's great. Even most of the social science field people are not aware about that. They, how can we will be field the patent and which process we will be follow. Even which legal things are there. So each and everything you have to highlight it regarding the patent, from the basic things to the technical things, as well as the legal advisor things also. So thank you very much, sir, for your valuable guidances. Even I know that from Indian fraternity or Indian professionals, so many long back years we are fighting for our saving our traditional knowledge also, because most of the foreign researchers, they will be come here, they will be do something research, and our traditional knowledge they will be theft. Actually, I will be say they will be theft our knowledge, and for that and they will be getting the more and more patents with their country. But all these traditional knowledge with have for Indian, we have our rights, but we are something, I would like to say that we don't have awareness about these things, particularly how to fill the patent and who can fill the patent and which things you have to need to be highlight in your patent. So thank you. I know this webinar is particularly for the IPR and patent, but due to my request, you have to highlight only patent. So thank you very much for that, because so lots of, you can say, the webinar are nowadays conducted in each and every institutions, but nobody is touch with the particularly with the patent. So thank you very much for that. And now I would like to introduce today's speaker, Ms. Pooja Menon, CEO of MyGrave Consultancy and Services, Vadodara, Gujarat. Ms. Pooja completed her BTech and diploma course in intellectual property rights. She is having 8-year experience in this field, and under her guidance as well as the MyGrave company team, within 2 years they have conducted more than 1,500 plus seminar sessions and workshops. Also, they have filed more than 450 plus patents, 1,200 plus prior art, 650 plus copyrights, and 2,000 plus trademarks within the last 2 years. So really, your work and your teamwork is really wonderful and appreciable in this research field. So I request to you, madam, please take a charge and enlighten to us in depth about the IPR and patent. Over to you, Ms. Pooja Menon.
Hello everyone. Sir, I'm really thankful for providing me with this platform so that we could actually spread the word of IPR more, actually not just in India, but outside India too. Sir, I would request if you could just give me the permission for screen sharing so we could start with the presentation.
Yes, ma'am, you can share.
Thank you. Okay, so as sir introduced, our company, MyGrave, has been conducting free seminars, webinars, and workshops to educate even students, industries, and everywhere where we could. Actually, we have a lot of talented people in India. So we, as a company, we decided to give away the knowledge of IPR so that everyone as an individual can grasp more knowledge regarding the same. We have addressed more than 32,000 students and industrialists in the last 2 years. And we are hoping, even in this pandemic, institute like you are providing us with multiple platforms so that we could, this good service does not stop. So I'm really thankful to all. So let's begin. Okay, so Nagre sir has already taken up regarding patent, where he has explained, multiple norms and clauses regarding patent. But first, we are going to take up the basics. We'll first understand what IPR is, what are the bifurcations, and what are you eligible of? Are you eligible of filing a copyright, a patent, or trademark? These words have been linked continuously with IPR. But what is the difference between them? What are the categorization? How we can analyze what type of IPR we should be filing? We'll be seeing it through the entire session. So there is a question on your screen. That is, all I asked was, can I patent my copyrighted trademark? If looking at this question, if you do not have any other questions, like if you do not have any confusion that why are so many words jumbled up into one question, then this session is very much important. Basically, there are two type of property. One is called the physical property, another is called the intellectual property. Physical property we all are very well aware about, like your land, the house you have, the car you own. These things are called your physical property, and usually people buy this using money. Now, whenever you ask them, how do you earn money, they are always like, you have to work very hard to earn money. It's not that easy. But what people forget is that it's not just hard work that pays, but there is a huge amount of intellectual work that you use to invest, to develop money, to earn money. Now, we are very protective about our physical work, physical property. Like, suppose if you have a beautiful bungalow, okay, and you want to protect it. Now, so imagine if I come for a cup of coffee and I loved your house. Now I'll be like, look, whoever is living here, I'll ask you to leave. From now onwards, I'll live in your place. Can I do that? Actually, no, because you have the original ownership. You have the, maybe it's a registered proof and evidence using which you can claim that the house is yours. Similarly, all your physical property are well protected under government registrations. Now, talking about intellectual property, that is what is created by you in your head. Maybe there is an idea, a concept, an artistic work, or literature work. Now, what happens is, suppose you are researching in a very enhanced field and an idea clicks. Now, it is a very usual behavior of human beings that whenever I have an idea, what I'll do is I'll obviously discuss it with one of my colleagues or maybe my friend who is quite intellectual in the same field. Now, the error we make is that, see, it's an idea. That means it is worth a lot of things. Means we do not know right now what the idea can be worth. Now, we discussed it with someone. Now, imagine if he or she published your work in their own name. Now, like the way you protected your physical property, you are not able to protect your intellectual property because there is no way to claim that the idea came to you first. Now, if that person starts advertising that idea as his, how are you going to go and stop that person or claim that the idea came to you first? Now, government, like the way you protect your physical property, they have provided a provision called IPR, intellectual property rights, secures your ideas, innovations, creativity, and they have created 4 bifurcations like patent, copyright, design, and trademark, so that you can protect different categorization of product into individual categories. Now, today's session will be bifurcating them, understanding what you can do and how you as an individual can take benefit out of it. So the first topic we are discussing is copyrights. Before we move ahead, I would like to say that if during this session you have any questions or queries, please write it in the chat session, so that in the end of the session, our speakers, our experts who have joined with us, we have Mr. Rinkesh who has joined us in the session. We'll all be helping you to clear all the doubts in this sessions. Okay. So moving ahead. So the first topic we are discussing is copyright. Copyright is very simple. Any artistic work that is created by you, that is maybe music, written a book, a play, a photograph, a movie, a choreography, all these things which are usually called as talents. Maybe you people do it for time pass, maybe photography, or which things do not have a logic. See, I clicked the sunset, or maybe I painted my sun blue. I am an artist. I can do whatever I want, and people usually appreciate those things. So the thing which does not have a logic, but it is done because of the creator's thinking and imagination, is usually secured under copyright. Okay, so usually people ask me that if I have done something very creative, why do I need to protect it under copyright. I'll publish my work, so it is more than enough. Now, let's take a day-to-day scenario. Now, imagine you have written a very beautiful article and you blog it. You have your blogging site and you just blog the article somewhere. Now, what happens is, whenever you have published your work, it is not just your family or friends who can actually see, view, or read your article. There are multiple multinational companies who are actually working in this field and who can actually read your content. Now imagine the data you have published is loved by some big company like HP, maybe Microsoft or Google, and they used your content to represent their work. Now they have used your work, your writing, maybe your design to represent their work without providing you any credibility, any monetary benefit. Now they are not your friends that you can go and catch hold of their collar and say, hey, you need to pay me for this. They are not going to listen to you. What? They won't even let you enter their gates. Now, the only document which can help you and serve you and the purpose of to get credibility is copyright. Copyright is an official document which can restrict another person from using your data without your permission. Now, as professors, maybe intellectuals in various fields, you may be publishing papers, writing, journals, and writing for journals, books, and all those things. Now, what is happening today is, if you want to publish a paper, you approach a publication house and you send them their data. They will have go through the procedure and then they publish it, right? And before they publish, they have a terms and conditions page. How many of you, please be honest to yourselves, how many of you have ever read the entire document completely? When you install a software, how many times have you read the terms and conditions? It's a human mentality. I agree. Sab karte hain. Everyone is doing it. So even I will do it. Right? Now, every time you accept somebody else's terms and conditions page, there is a clause called IPR. Now, what happens is, they have clearly mentioned that in case the data which you're submitting to us is accepted by us, the copyright will be filed under our name, and we from now on will own the ownership of the entire data. We will have the rights to use it, misuse it, translate it, and do whatever with it, and you cannot claim against us. Now, what has actually happened is, suppose you have a house and you wanted to rent it to someone. Okay, instead of renting it, you actually gave away the entire house for free because you were not aware what you're signing in. So when you're very careful about your physical property, why are we not very careful about our intellectual property? The actual thing which you should have done is actually file a copyright first, then provide it to the publication house so that they can go through it and only have publication rights. See, the problem you will face is, suppose you want to write a book and use the same content of the published paper, you will not be able to, because then to have the ownership on the content, you will have to take permission from the publication house. And believe me, we have seen this problem happening. There will be multiple professors who have joined in during this session. You create notes, presentations, lectures, and multiple times you would have seen somebody else using the same data to earn money out of it. This problem has been faced by multiple people. So this should not happen with you. So you should file a copyright and then move ahead. Okay. So here is an example which we can take and understand better. See, what happened was, when Obama sir was fighting for the election to be the president, one of the press agency clicked a photograph of his, and it was beautifully modified and worked on with red and blue combination with the title Hope. Now, what happened was, this beautifully created image was published in their newspapers and journals. And during the election time, Obama sir's council member requested that for the election, we need new banners so that, we can grasp more votes. Now, what happened was, when this request was made, the advertising agency who was responsible to create the banner, instead of creating an entire new banner with his face, picked this photograph from the social media account and used it for their banners with the title Hope. Now, this news banner was obviously published in the entire country, right? Now, the news media agency who actually created this image saw the banners. One of the member walked into the council office of Obama sir, and they requested that, sir, we are from the press media and we have some requests for you. So people started laughing. They actually were very happy because they were news media agency. So they welcomed him very well, and they were like, "Yes, sir, please tell me, what do you want? A backstory, or maybe a history of how he is going to be the next president?" They were like, "No, no, we have quite enough information, but the new banners which you have used, we want you to remove it right now." All the people started laughing. They were like, "Do you know what you're asking for? Are you drunk? Do you know where you're standing?" He's like, "I know that you people are not going to listen to me, but the image which you have used in the banner was created by my company. And you, without our permission, is using it without giving us any credibility. Now I will go out into the media and will scream that the person who wants to be the president of USA does not follow basic copyright rules. What if tomorrow he takes away all our rights?" See, this is not a big agenda, but during an election, a controversy will help the opposition party to earn more support. So what happened? A very smart person from the council office came ahead and was like, "Sir, the banners look very good. We cannot remove it. It's our prestige issue. But tell me, till the elections are over, how much should we pay so that you could keep your mouth shut?" Very smart fellow. So till the elections, this news was not out. The news agency got good amount, and that was only possible because of IPR filing. This people had copyrights over this image, because of which they could even stop a powerful person from, not giving them any credit. So this is the value of copyright. So if you have copyrights, you can actually stop any person from using or misusing your. Even when you have copyrights, nobody even can translate your work. So please be careful that if you have copyright, nobody else can use it, misuse it in any form possible. Okay. Oh, see, when we talk about copyrights, it is also important to realize that it's not just our work being copied, but when we use somebody else's work, we should be very careful, because there are possible that we get caught up into infringements. See, if you are in an education sector, as per government law, if you are in mass media, that is your news sector or education sector, you can use somebody else's work for educating an audience. If you're not doing it for a monetary basis, you can use it as a faculty. If I want to teach someone and I'm using somebody's copyrighted material, it is okay. But if I'm earning money out of it or fame, then it is a big violation. So here what happened was, there is a company called Epic Systems. Now what they do is they create softwares for hospital chains in USA. Now what happened was, when after the softwares were installed into the hospitals in USA, they hired TCS from India for the maintenance work. Now, we always need to know that if you are going to work in a multinational company, then whenever there is a contract between different companies with your company, they always try a non-disclosure agreement or a confidentiality agreement, which states that because you're accessing our private confidential data, you are not allowed to use or misuse it for your own benefit. Okay, now what happened was, the employees from TCS went down to USA to work in under this company and the software. They were not aware of the confidentiality clause. Now what happened is, when they started working on it, they loved the software which was created. They came back to India, developed such a same software for the hospital chains in India under the name MedMantra. Epic System came to know about it. They slashed a legal litigation against TCS worth $940 million because their data was used or inspired from. See, when you're talking about IPR, there is nothing called inspired from. If you're using somebody else's data, you're using somebody else's work to create your own work, then copyright infringement is a bigger claim. So you all need to be careful that when you are creating a book or a design and going to sell it into the market, and if you have used somebody else's article, only giving credibility that I have used so and so's work won't be allowed. They will be waiting for a monetary benefit. So you have to be very careful when you're using somebody else's work. Okay. So I hope copyright is clear. We have seen multiple copyright infringements happening. Even we usually get involved because we think everything that is public is for free, but it is not like that. You have to be very careful. Anything creative, songs, music, software, even all the websites that you view, the photographs that are available on the public platform like Google, it is all copyrighted work. So you need to be very careful that which work are you picking. Okay. So if you have any doubt regarding copyright, you can just write it down in the chat section. Our experts will be going through the same and we'll be addressing everything at the end of the session. Okay. So moving on to the next topic, that is trademark filing. Now, copyright secured your creative work. Now, talking about trademark helps you to protect the brand identity. Now, suppose I want to buy a product, or maybe I want to find a company. Now, how do I recognize them? Usually using their name, logo, symbols, taglines, jingles. These things actually provide identity to a product. Let's take few examples to understand better. Now I'm driving through the road and I find a capital yellow M. I'll recognize it as McDonald's. It's a food chain, right? Similarly, if I'm wearing a plain black t-shirt and there is a small tick mark on it, it's the symbol of Nike. So every company, whoever develops a symbol of recognition, have trademark on it so that no competitor company can, infringe it or use it for their benefit. And that identity becomes their recognition factor. Okay, so everything that you see, even the some of the taglines and jingles get very famous. Like when we are talking about, there are multiple, just do it. These taglines are very well known and they actually create identity. Now, multiple other things are also trademark, like sound, smell, dialogue, voice, three-dimensional design. Now, why? Suppose I go down to buy a perfume, then I will not buy a perfume by just looking at the brand. I will definitely check the smell, that how good I smell using, when I spray it. Every company who manufactures deodorants or perfumes have their brand name trademark, have their smells trademark, so that no other competitor company can launch the similar smell, which is actually the recognition of the perfume, using their own brand names. So every perfume that you smell in the market is actually trademarked by the official company. When we talk about sound or dialogue or voice, when we were kids, we used to watch Tom and Jerry, right? The sound of the lion, the roaring, which is heard in the beginning of the show, is the official trademark of Walt Disney. And nobody except them can use it. Even when the lion sound is heard, there is a symbol called TM besides it. So that actual sound is trademarked by them. Okay. Every cartoon character that you see is trademarked. And you would have experienced this when you go down to buy official merchandised products. Like if you want Superman, Batman drawn on a t-shirt of your kids, maybe, or your, some relatives or cousins. And you will see that the normal cost of a t-shirt is much less than the official merchandised cost with a symbol of a Batman or any cartoon character. It is because there is a character merchandising law which applies to every character. That means the person who prints the character on the t-shirt has to pay a royalty amount to the creator of the logo. And obviously, if I am a manufacturer, I won't pay the entire amount from my pocket. So who does pay it? As customers, we do. So whenever we buy official merchandising, we are not just paying the manufacturing cost or selling cost, we are actually paying a plus royalty amount for the logo which has been printed on my t-shirt. So now you know why what is the meaning of branding. It's not just a brand value, it's actually the royalty value to the brand, to the symbols which has been created by the owner. Okay. These are few of Indian famous trademarks, like Amitabh Bachchan ji's voice, Sunny Deol's voice, Kapil's famous dialogue Babaji Ka Thullu. These things were trademarked in India. Even few celebrities and cricketers have rights to trademark their name. Now just think, can I, as a common person, trademark my own name? Can I trademark Pooja Menon? No. It is because, just let's take an example and understand. If Sachin Tendulkar starts selling water purifier on television, like, you should buy this RO water purifier, it is good for health, people will rush to the store to get it because they feel that Sachin has become such a great cricketer by drinking water from that RO. Okay. Now imagine if I go down selling the same RO water purifier, I will look like a saleswoman, right? So that is the difference. These people are already a brand and they create an impact into the market when they start selling products. So government has given them the permission that nobody should use or misuse your name and sell products by your name. So they can protect their brand name, and nobody can use their name without their permission. And I, as an individual, can trademark my product's name. Now, suppose I want to start a business tomorrow. I want to trademark the company's name, the software's name, the book's name, or whatever content I am creating. If I want to trademark the name of the product, the company, or anything that I'm creating, I can do that. But my own name, I can only do when I am a celebrity. I should have a brand value. Only then I can trademark brand name. Okay. See, these are few things which we need to take care that if we try to create a brand and we decide to, just copy paste a bit so that it creates an impression of a bigger brand, these all things are illegal. If you try and attempt, government won't provide you with the registrations. See, like you cannot use the colors combination of BMW and create a brand BYD, or create a bike called Gulsar and just to replicate the brand name Pulsar. You cannot do that, because government will check it phonetically, that is the pronunciation, along with the spelling. If they find anything that is closely related, they will clearly object the registration of your brand. And as we are talking about the registration, you would have seen the symbol TM or R written on the logo, right? Now, a lot of time you would have seen TM and a lot of time you would have seen the symbol R. Now, let's discuss the difference between them. TM is the permission, that is temporary mark. It does not mean trademark. That means you can apply for symbol TM when you have just applied your application. That is, you have just informed to the government that this brand name needs to be registered. Now, government gives you the permission to let everyone know that this is an applied trademark. Once the government completes the examination and the entire procedure, it will give you the permission of registration. That is, it's a only symbol that can be used by you in the entire country. That is when the symbol of TM converts into R. Easier language, it is like an engagement and marriage. If you are engaged to a person, you can tell everyone that she is yours or he is yours, but you're not still sure that you are, end up together. But marriage is like final. It's like R. That means after this, nobody else can have him or her as their possession. So that is how the trademark is. TM means temporary mark. It gets converted into R. Then you can take legal action against anybody. Otherwise, till it is TM, you can warn others that this is your mark. But you cannot claim the entire rights on you until and unless it is R. Okay. So these are few of the valuable trademarks, which the word Google alone has a brand value. Only the name Google has a brand value of 44.3 billion. Now it has gone up. It's a 2-year-old data, so it has gone up. So as your company develops, the brand value develops. So with the trademark, you can actually enhance the brand value and create more trust into the market. Okay. So I hope trademark is clear. And if you have any doubts, do let us know by the end of the session. Okay. So now the most important topic, that is patenting. See, copyright secures creativity, which does not have a logic. But when you talk about patent secures everything that can answer why, how, and what. If you have the answer that for what you are applying for patent, how you're going to do the procedure and why you have to do it, then you can go for a patenting. So patenting is categorized into 3 sections. One is utility, other design, and third is plant. Now let's understand the difference between all the 3. See, plant, obviously, if you are there is a genomical modification into the development of the the plant, then you can go for a plant patent. But utility and design is quite interesting. Now, suppose I have a bottle. Imagine. Now, what happens is there are multiple companies who are creating bottles. If I am just changing the shape of the bottle, that means there are multiple companies like Bisleri, Kenley. What are they all doing? They are just manufacturing bottles in which water is stored. There is no additional features to it, right? So when I just change the design structure of a product, I will file for a design patent. There is no change in the working, the method or efficiency. It is just the design structure which I'm changing. I'll go for a design. But if I provide features and characteristics to a bottle. Now, suppose I have a bottle of Milton. Now, what does this do is if I pour in hot water, it will retain the temperature for 24 hours. Now, the property of the bottle changed. That was a plain bottle which could just store the water. But here I changed the features and characteristics of the bottle. Then I'll apply for a utility patent. So very simple. If I have a method, a process, a working mechanism where I want to secure the components, working principles, and everything, then I'll go for a utility patent. But if I have just changed the design structure and enhanced it to make it look better, maybe to perform better, then to store more into it, then I'll go for a design patent. Okay, so I hope I'm quite clear regarding both the differences. Okay. Now, what cannot be patented? See, when we are discussing about patent, there are a lot of questions that what can be patented in India? Are the norms different? Yes. See, these are the rules as per the Indian jurisdiction. If you want to file a patent in India, these things cannot be patented. So it is very easy to understand that if these things are not patentable, other than this can be patented in India. Okay. Nagri sir has covered a brief information about this. So we'll just take a bit of elaboration so that we are quite clear that these things are not patented. Okay. First, scientific principles or formulation of an abstract theory. This means like there are certain laws like the law of gravity, law of motions. So these things cannot be patented. These things are scientific principles. They are working and these things cannot be patented. Abstract theory like time travel. Till now, it's just in theories. We have not actually seen any product using which we can actually time travel. So these are abstract theories. So until and unless you don't have a working methodology, you cannot patent those things in India. Okay. Discovery of a living or non-living substances. See, there is a difference between invention and discovery. Discovery means something that already existed and you just found that thing. So those things which are already existing on the earth or maybe in the universe, if you have just identified those things and provided it to the world, those things cannot be patented in India. Yes, you can give it your own name for a recognition, but you cannot patent those things. An invention which claims anything obviously contrary to well-established natural laws. This is very good to understand. If there is a natural law which works, like law of motion. Now, if I push up, a ball, it will roll, and if the frictional force will help it to stop it after a certain end. Or maybe if I provide an input energy, it will provide me with an output energy. But if I talk about a concept where I don't provide anything as output, but I get continuous output energy, it's literally against the law of nature. So those theories cannot be patented. If I talk about infinite energy, there is still a restriction to it. So if such things right now government considers as against the established natural laws, if such things you are trying to file, government will stop you against a patent registration. Third, an invention which causes serious prejudice to human, animals, and plant life. If you have created an invention which is harmful for human life, animal life, then they won't permit it. But something that could help human to do something better, like for example, pesticides. Basically, it is harmful, but it helps you to protect your crop against insects and pests. So that is patentable, but because it is not harmful to humans. So those things can be patented. Okay. The mere discovery of a known form of substances. That means a product exists. You just changed the form without any enhancement to the efficiency or working or methodology. Then you cannot patent it. Mere arrangement or rearrangement or duplication of known device. This needs to be understood very carefully. See, there are multiple people who come down to us. They are like, I have two different products and I have merged it into one. Now, can I patent it? Like, for example, I have a chair and I attached a torch to it. So now whenever I want to access the torch, it's very easy. But see, both the instruments work independently. If the torch is separate and the chair is separate, they will work independent of each other. Those things are just mere arrangement. There is no physical change, efficiency change. But now I enhance the product. The torch which is attached to the chair gets charged every time a person sits and stands from the chair. And the torch will only switch on when a person is sitting. If I leave the chair, the torch will get switched off. Now, both the instruments are working parallel to one another. If that happens, it's a patentable product. So you need to understand when you're trying to apply, combine two technology into one, they need to work interconnected. If they can work independently, they are two different patents. They are two different products, not even a patent. Okay. A method of agriculture, horticulture. India is an agriculture-based country. If you find a method of agriculture to grow something better in a natural way, not using technology, if you're using a natural method of gardening or horticulture, then it is not patentable in India. If you're creating a machine to enhance the agriculture productivity, that is patentable. But a natural method of agriculture is not. Okay. Any process for medical, surgical, curative. Similarly, if you have find a method to treat a patient, to analyze a patient's physical problems, then it is not patentable. But you create a machine or an apparatus which can be helpful in the medical sector, it is patentable. Okay. Plant or animal as a whole. If you found a new entire animal, you cannot say it's patentable. It's in discovery. So that is not included. So if you have done some modification into the characteristics with, working with the DNA and RNA, then yes, you can go for it. A business method, mathematical equation, computer program. In India, see, this law is only applicable in India. US, other countries allow patents in computer programming and business, business methods. But in India, if you have created a business idea, like online selling something, or maybe, anything which is related to business development, it is not patentable in India. Second of all, if you have a pure computer algorithm or a pure mobile application like WhatsApp or something like that, it is not patentable in India. Like online selling, there was Amazon, so India has Flipkart. Similarly, if there was Airbnb, now we have Oyo. So business ideas, mobile applications cannot be patented in India. But yes, in US, they accept it. So they have different laws. Okay, mathematical equation, it's not patentable in India. Any invention with effect to traditional knowledge. See, we are a country which believe that we have been blessed with a lot of ancestral knowledge like Ayurveda, yoga, and India believes that these things needs to be given free of cost. We have been fighting with multiple countries outside India just to claim rights. Few days, like there have been patents on use of turmeric, use of neem, use of cow urine in medicational purposes, which are actually very well stated in the books of Ayurveda. But still, as a part of country, we do not allow those things, which is a traditional knowledge. Okay. Now, talking about patents, we need to know that 90% of the patents being filed in the world is filed on improvements. That means the product already exists. Now, I'm not satisfied. There are some features that can be enhanced, made better, look better. Then I can file a patent. Government only wants 1% improvement in the existing product. Only one claim which is different than the existing one, I can file a patent. Like, for example, this is one of the very good examples. There were gramophones, then came tape recorders, cassette players, CD players, Walkman, iPods. All these instruments were used to listen to music, features apart. Now, somebody thought that I want to walk and listen to music. Practically, holding the gramophone in my hand and walking on the street is practically not possible. So someone came up with the idea of Walkman. And now I can actually walk on the street and listen to the music, right? Like that, every instrument around you has been modified for your benefit. Like first there used to be STD PCOs, right? To give a call to someone. Then came the time of landline phones. Then we had cordless so that we could walk freely and talk to our friends. Then there are mobile phones. And now there are hundreds and thousands of designs of mobile phones. Every time there is a new modification into your apparatus, it is patentable. Whether it is the design or whether it's one of the feature, then it is patentable. Okay. See, this is one of the very good examples where even after an invention went wrong, it made to a $1,000 million business. There was a very good chemical engineer called Spencer Silver. Now he was trying to develop a glue, a gum using which he could stick anything in this world, a wood, plastic, maybe iron, everything. But what happened is, at the end of the result, in the year 1968, he found that the glue was of no value, because instead of a strong gum, he created a weak glue. He was very upset, but being a scientist at heart, he again applied for a patent for the formulation which he had created. Down in the 1970, what happened was, he had a very good friend called Arthur Fry. One day when he went visiting that person, he saw he was, sticking the notes. Usually whenever we read a book, we write notes. He was sticking those notes onto his book using a stapler. Now, Spencer was curious and he was like, why are you trying to spoil your book? He's like, look, people take my book to read. They usually lose the notes and then I have to again make those things. Those are much painful things to do. So I decided to stapler it. He's like, I have a glue and maybe it can help, to do this thing better. Arthur was a bit confused, but Spencer was very happy about doing it. So what he did, he took the note, he, obviously pasted the glue and he closed the book. Now, when he opened, the page did not fall. Now Spencer was a bit scared because if it got permanently stuck, he'll owe Arthur a new book. But to his luck, when he pulled the note out of the book, the note came very smoothly, detached from the page. We all are using the sticky notes, the yellow pages, just to write our notes and reminders. Those sticky notes were invented by these two geniuses. They started their business under the name Post-it, which is still a brand and available. And a glue which had no value is till date used for the same purpose. Imagine an invention which had no value, but now it is $1 million business because every educational person, every person in the offices are using it. So you do not have to worry if your patent does not create a value right on. But with the time, when the actual, there is a need, then people will recognize it. Okay. So there are few very easy patents filed, few big gigantic patents filed. So let's take some examples. In 2002, a person filed a patent for a method of swinging. Usually we are allowed to swing in 90-degree direction. The person said it's very boring. This is a usual method which people have been using. Now I have a method using which we can swing in 45-degree angle and it is more fun. And he actually practically proved it, because when we were swinging at 45-degree angle, the sensations in our head felt different and it gave out more pleasure thoughts. So it created a new patent idea and it is a granted patent. Not just an applied patent, it's an approved granted patent. So every small thing like this even gets patented. Everything that you touch around, the toothbrush which we use every day in the morning is also designed, patented by all the big companies. Because for you, it may be a 2 minutes thing, but for them, it's a $100 business, right? Here, few of the rat catching devices have been patented. Look, there is a beautiful cat shaped, just to catch mice. Why? The rat should feel good, right? I'm going to get caught, so I should get caught in a beautiful design. No, obviously, it is for our benefit, right? If we use the bad looking aluminum like box into our house, and if somebody just walks into our house to say, hey, and they find that nice box in our hall room, in our drawing room, it will create a very bad impression, right? We will have an entire Swachh Bharat Abhiyan in our house. A lot of people complaining that these people are not even hygienic. They don't keep their house clean. But imagine a beautiful cat shaped, box in our hallways. And if somebody walks in, they get misguided that it's a showpiece or maybe a toy which is kept. They won't find it that these people have problems of mice at home. So everything that is being modified and around you has been applied for patents. Even the cups that you hold early in the morning has been patented by different companies. So that is the value of patent. It does not have to be a big thing, but it just has to be something that does not exist right now. So it can be patented. 1% improvement can give you a scope to file a patent. Okay, so as we were talking about utility patent and design patent, here few companies have applied for both. And why it is important, we can understand using this slide. See, the company Apple, as we all know, they created a watch clasp. That means usually whenever we try to adjust the clasp of the watch, it has to be adjusted as per the size, right? Now they created a clasp. Usually if we have those holes, we have to, if the wrist size is small, then we have to create a new hole to adjust the size of the wristwatch. What happened was they created a self-adjusting clasp so that nobody has to cut short or create a hole. It can be self-adjusted by just by using the clasp. So it became very flexible to be worn by different wrist size people. Now the concept, the working, the method, the component, all those things were filed under utility patent. But when they decided to implement the same concept into their product, they filed for a design patent so that nobody else can create the design and file for a patent. Now, we need to understand that suppose you have a product and you file for the concept and you have patent on it. Now, if you decide to market the product with a new design, and if somebody else has the design patent of it, then you will have to purchase the rights from them. See, understand, both these things, utility and design patent, are individual of each other. You can have patent on somebody else's concept. Now, you came to know that Apple is working on a new design. You came to know about the design and you file a patent on it. Now, from now on, it is your idea. Apple will have to come down and pay you to use the design. So you need to be very careful that whenever you invent something, if you have a design, file for a design patent. If you have the working, file for a utility so that nobody else can restrict you from using both. Okay. Similarly, here, Apple company created a concept of foldable mobile covers. See, the patent of foldable mobile phone, foldable mobile screen has been owned by other companies like LG and all. So what they said is, if we use the normal mobile cover and fold the phone, the edge will come out. Imagine you have a 50,000 or 1 lakh rupees mobile phone and a bad phone cover. It will look so bad. So now Apple has the rights on every foldable mobile covers with flexible adjustment. So whatever side the phone bends, the cover will get adjusted to it without any problem to the phone. So now every phone in the market, whoever sells it, they have no problem. But every mobile cover which is sold, they will have the rights on it. So they have a bigger market than the mobile phones. So you even need to think in the same direction, that the product already exists, fine, but what are the other requirements around it? If you have patent on that, you can ask the company to pay you so that they can use it. That is how the entire patent industry works. You don't need to have a prototype. You don't need to have a product to file a patent. An idea, a theoretical idea on paper is more than enough to file a patent. So the only thing you need to do is have a patent, sit, let somebody misuse it, and then you can take the paper and claim your money from them. It is that easy. It's a huge business, right? Similarly, when Apple created the mobile cover for their phone, they had design patented for it. Okay. This is one of the very good examples. People usually ask me, how important is design patent and utility patent? Yes, utility patent may help you to secure your concept, but design patent has a higher value because multiple output can be achieved from it. See here, multiple patents have been filed for the design of the needle. A needle can actually revolutionize the entire process of stitching. First, we used to use the needle to stitch it using hands, right? We had which our parents usually use to just stitch the clothing. Now, when the eye of the needle was shifted from the top corner to the bottom corner, the entire clothing industry changed from hand stitching to a machine stitching. Every needle used for stitching cotton clothes, leather, jeans, denims, all those things have been patented. Even the safety pin which you use was patented. So every small thing that you touch can create a revolution and can be filed for patent. So you do not have to think for a big idea. You have to think for a small idea which can actually create a bigger change, and that can be patented. Okay. The Apple phone which you hold, usually people say they are very expensive, but they are not just expensive for no reason. a single mobile phone has more than 200 patents. Everything from the screen, the screw, the battery, everything that you touch in an Apple phone is patented. They know how to create a market. Even if you lose a single screw, you will have to buy it from the Apple shop. You cannot buy it from the local shop. That is how they create their economy. And only because everything is patented, their products are expensive, because obviously they take care of a lot of things. Okay. So here we'll discuss few patents and then we'll move a bit fast ahead so that we can take more questions than just explaining about the patent. Right. See, the company Amazon, apart from delivering products, as per our impression, it is just a company which deliver products maybe, but they have multiple patents and they have a huge business chain. One of their patents are on drone system to deliver underground. That means, okay, flying above, there are a lot of patents, but they said using underground tunnels. India still does not have underground tunnels and subways, but outside India, there are a lot of countries which have underground tunnels and subways for traveling. They are using those systems, tracking the GPS, and the drone will itself deliver it without creating any traffic or commotion or any problem. They have such patents. Okay. Google have patents on weather triggered programs. See, they are into advertising. And if because of the privacy, if we stop sharing our data, Google cannot provide us with optimum ad. So they created a patent where the computer is able to identify the weather of where the person is accessing. So now I'm in Gujarat and it's raining heavily. So now Google already knows that here it is monsoon. So it will start presenting me with ads which are related to monsoon goods. Then I will have to buy it. So that is how one of the patent of Google works. Okay, so I think these are few slides which talks about the importance of patent, but I think Nagaraj sir has very well covered it, where as an industrialist, as a student, as a PhD candidate, as a researcher, you can have academic benefit, be an entrepreneur, have startups, get a better job, because in India, there are only the natural filing which happens is only 50,000 last year's data. In 2019, let us all scream about China and Chinese products and everything, but they are number one in patent filing. In the year 2019, they had 15,42,000 patents filed. And after that comes USA with only 5,96,000. There is a gap of 10 lakh ideas. And how can you stop a country like that? Apart from all this, India is in rank 7. Please don't be happy because we're on 7th at least. No, we only have 50,000 patents. And in those 50,000, 60% patents are filed by the people outside India. That is, if Google comes to file, if Amazon comes to file in India, the count is recognized in Indian patents, but they are not Indian patents. They are just the filings in India. So only 40% filings are done in India. And in that also, maybe a 1% filing is done by individual person. That is me filing. The companies like, TCS are already filing for sure. But we as an individual, only 1%. So there is no competition here. If you want to have an academic benefit, maybe as an entrepreneur or as a startup, there is huge opportunity in India, because still the patent culture is a bit slow because of the awareness. We are not quite aware that how we can do it. And see, patent procedure is not at all expensive. It's very easy. You can self-file it. You don't need a lawyer to do it. That is the best part about patent filing. No lawyers, no degrees. India's youngest patent holder is only 9 years old. And presently he's 14 and already has 9 patents in his own name, without a degree, without a qualification or anything. And in the world, the youngest patent holder is only 6 years old. So age, qualification does not matter. It is the idea and the novelty which you have, using which you can file a patent. So I guess we can move ahead to the question and answers round, so that we can address more of the queries than going ahead with the session.
Thank you very much, madam, for a wonderful session. Actually, the session was very informative, energetic, and you can say the knowledgeable concepts, and each and every concept you have clearly, you can say the clear all the doubts of the participants regarding the copyrights, trademarks, patents, and even what can be the patent and what cannot be the patent, even types of the patent, that is the utility patent and design patent and all the with the help of the examples, practical examples. Really, I know that the so many people are aware about that. The how can will be fill the patent and which things can be in the patent and what can be not in the patent. And some fears also have mind in the researchers, that is the if I will be fill the patent, so I will be get some legal actions about that, because we don't have our full database. Even we have databases of the patent, but not much more their awareness about that databases and procedures in between the researchers. So thank you very much for your very good speech on the copyright and on the patent. If anyone have questions, so please raise your hand also, those who are available in the Zoom. Also, some questions, madam, has some participants have raised on the YouTube channel. So just a minute, I will be asked to you. First question is that from the Dr. Anil Chikate. Is there any age limit for the eligible for apply for any type of the patents?
Okay. Sir, I just discussed that there is no age limit when you're talking about patent, because there is no criteria. When you're filing a patent form, there is no criteria asking you what is your age, what is your qualification. No, just your name, address, email ID, and phone number. That is what they are asking for. So you can, if you have an idea, whatever your age, you can file a patent. If you are filing a patent and your kid is in class 6th and you want to add his name so that whenever in future he can take advantage of it, you can do that. There is no restriction. There is no age restriction. And sir, when we were discussing, when you were just speaking, you said there are fear that whenever we file a patent, maybe there are legal actions. Then what can we do? See, there are no legal actions. What will happen is your document will go under examination. If government has some query, they will raise it. Nothing, no third party is going to jump on you and say, you have patented my idea, it is already patent, product is available. No, the government will inform you. You can pull back your patent application very smoothly. It will only get published once the government, if there is any problem, it will only happen after the government has granted. And see, if government says there is no problem, then nobody else can say there is any problem. So don't worry, government will first inform you, and then you can decide whether you want to pull back or fight for it. So there need not be any fear when you're filing a patent.
Yes, Rinkesh sir, you have any questions with you? So please ask, madam.
Okay. Ma'am, I have received few of the questions like this is asked by Vipul Chalotra. Why many garment sellers copy the trademarks and sell openly in market?
Okay. First of all, it is illegal. Let me tell you, even if you are buying, that is okay. But whatever they are selling in the market is illegal. See, you may think that if we walk around the fashion street in Mumbai and you can see multiple people selling this logo in very cheap prices, there are government agencies who raid these people and stop these things from happening. That is why whenever they see a police van, they'll pack up everything and run. There have been infringement. One of the cases with our clients, they were selling the tubes and tires under the name of Honda. And what happened was Honda filed a case in the in the court, High Court, and multiple police squads were sent, and wherever they found infringed products, they burnt the entire garage with the products. So do not think that these things are not happening or these things are being used or misused. They can do it till nobody finds it. See, in India, there are things which go under table. We know that. But if the police or the government is very strong, they will stop these things from happening. And India being a developing country, some things are taken very liberally in India. So, but still these things are illegal. You buying is okay, but if you decide to sell, that is where you will come into the wrong picture.
Okay. Another question is asked by Sharmila Jajodia. Can we use the TM cartoons for educational purpose?
Yes, you can definitely use, like in our presentation where we have used the cartoon characters, they are all registered trademark of the company. But I am just using it to educate you, just to show you that these things have been trademarked. I am not creating my own cartoon channel and using it for a monetary benefit. It is the purpose of use. Like the cartoon characters, if I'm using it for my own monetary basis, create a cartoon channel, it's illegal. Using it to explain to people, it's okay, no problem. Just for your college presentations, your online sessions, it's all okay. Until you're not earning money or credibility, it's okay. Done.
Okay. Another question is from Falguni Bhattacharya. Madam, I want to patent a biomoleculars out of research which is wanting by the farmers. What I have to do?
Rinkesh sir, can you please take up the question?
Can you repeat the question, sir?
Yeah. Madam, I want to patent a biomoleculars out of research which is wanting by the farmers. What I have to do?
Okay, the first of all, if the biomolecule which has been developed by the researcher, if it is genetical modification of the natural thing, then it is patentable. If it is not a genetical modification, it could not be patented. Now, the question is, if the biomolecule which is genetically modified, then first they need to take the permission from NBA, that is National Biodiversity Act, and has to submit it as one sample to the MTCC center or ATCC center. For MTCC center in India, it is available in Chandigarh, where you need to submit your sample in a depository of the WIPO. Okay, this is the thing. And if you need the detail of how the filing has to be carried out, you can visit our YouTube channel, where we have already given the detailed procedure, because it is not possible to tell the entire detailed procedure of filing within a span of 1 hour. It will at least take 4.5 hours to 5 hours to complete that stuff. We have packed it in a very short span in a YouTube video. You can just scroll our YouTube channel and you will find that video if you have further thing, or you can just reply on a mail so that a specific query can be adjusted like that.
Okay, okay. Thank you, sir.
Sir, I'll just need to add a few things into it. So for patent filing, there is no restriction. Even if it is needed by the farmer, they can file a patent. But yes, if the farmer decides to use it, then you cannot stop the farmer. That is the biggest problem. Like the few cases which we fought with the company Lace, the potatoes which were actually their patent was grown by few farmers in India. Lace filed a case against those farmers, and because there is a law called innocent infringement in India, that means the farmer is not educated, they don't know about patents, so they have grown it. Now because the case went into Supreme Court, they were like it's innocent infringement. Lace had to apologize to the farmers and pay them for all the potatoes that they took from them for Lace. So in India, these things are very open. You can have a patent right on something that you have developed, but if it's used by the farmers of India, they will go under innocent infringement at times.
Okay, thank you. We have take these few questions from the live chats. If any participants have those who are available on Zoom, they can raise their hand. Even if you want to any feedback regarding this webinar, also you can raise hand. So we will be allowed to use speak. Anyone?
Sir, there is a question in the group chat where the madam is asking, mutation breeding in chickpea has been done by her, and can she patent the same work?
Mutation has been created. Okay, ma'am, you have DNA fragmentation or PCR been done over here, and if you have inserted that particular genome sequence into the DNA of that to get that particular breeding mutation, then yes, it can be. But the very important clause over here comes that when you create a mutation, and if it is creating an environmental impact or it is going to have any adverse effect, then it can't be patented, or it will come into the FAI report that it can't be patented. So we need to check that if it is not going to harm anybody, or it is not going to harm the environment due to that mutation caused to the flora and fauna of that particular region.
Okay. So thank you very much, madam, and even Rinkesh sir for a wonderful question and answer session. Now we one announcement to the participants. Feedback links already I have shared on chat box of the YouTube, as well as I will be shared in the Telegram group. Link will be open only for the 30 minutes. So please be cautious about your name. Those name you have inserted in the feedback form, it will be applied on your certificate. Now moving towards the vote of thanks. First, I would like to thanks to Dr. Kantilal Nagare sir and speaker Ms. Pooja Menon as well as his team for accepting our invitation and enlightening to us about the patent and intellectual property rights on this occasion. So I greatly thankful to all of you. Also, I would like to thank Principal Dr. Vasant Mali for permission and guidance for this event. Also, thank to all our college authorities as well as staff members for kind support. My special thanks to Mr. Chetan Taksale, Director of Softex Solution and Services for their technical support as well as live streaming on the YouTube. Even I would like to say thanks some eminent personalities, those who are available for this webinar. That is some principals also participated, some directors, some head of the department, some scientists. So can say the possible to take name for each and everyone. So thank you to all of you. Last but not least, I thanks to each and every participants for their huge response as well as valuable presence in this webinar since last 2.5 hours. So thank you to one and all. Again, I would like to say that please fill the feedback form. Your certificate will be issued within the 8 to 10 days, and I will be share the downloadable link of your certificate in Telegram group as well as on your email. So please tune with us, sir, and thank you very much to all of you. Thank you. Madam, thank you. Nagaraj sir, thank you. Rinkesh sir,
Thank you, Nagaraj sir. Madam, thank you. Thank you to all.
Chetan sir, live streaming stop करा.
Yes, yes.